Coomaravel Pyaneandee against Lam Shang Leen.
Good morning.
Hello, my lord. It please your lordship, your ladyship. I appear for the appellant, together with my learned friend Eve, who is on my left, and my learned friend Arvin Sugu on my right. My learned friend Anna Choi, King's Counsel from the English Bar, appears for the respondent, together with Miss Kamlesh Doma of the Attorney General's Office of Mauritius. My lord, my ladies, this is an appeal against the judgment of the Supreme Court of Mauritius, setting aside an application for judicial review. The appellant had applied for judicial review against the finding made by the Commission of Inquiry, which was composed of the three respondents. The Supreme Court refused leave to the applicant to appeal to the Privy Council, and we are greatly indebted to the board for having granted leave to the appellant.
Yes, you can take it, Mr. President, that the board has read the judgment below, the transcript, and the cases of both parties. So you can the background facts we are familiar with, but we are happy that you draw out those which are important to your submission.
Indeed, my lord. Thank you. My lord, the parties have agreed that there are 4 issues to be determined by the board, although one issue there will not be much focus to the extent that the respondent ultimately have agreed to place the transcript before the board. We shall be short with respect to that ground of appeal.
Yes,
but then,
that in some ways that is now historical, but it is relevant, obviously.
Indeed.
It's relevant to the question whether the Supreme Court were properly able to adjudicate the matter without having the transcript before them.
Indeed, indeed. So, Lord, the proposition of or the submission, I should say, of the appellant would be as follows. I shall first deal with issue B with respect to whether the Supreme Court was right to find that the extract of the report did not constitute finding and hence were not judicially reviewable. Our submission will be that your Lordship will forgive me if I use the term finding, because this is the issue which your Lordship will have to decide, but without being pretentious, if I do use the term finding, you will understand my position. Our position is that clearly the extract in the report pertaining to the appellant were clearly findings. That is one. In the alternative, if they were not finding, our submission would be that they were in the nature of comments and observations which were clearly prejudicial to the appellant and hence judicially reviewable. That is issue B. I shall then move on to issue D with respect to whether the Supreme Court was wrong or not in failing to call for the written transcript. Our submission is that, first and foremost, the Supreme Court should have called for the transcript. I shall then deal with issue C, and our submission will be that those findings which were adverse to the appellant were reached by the Commission in breach of the principles of fairness and in breach of the rules of natural justice. And the last point we will make,
are you drawing a distinction between the principles of fairness and breach of natural justice, or is that really saying the same thing?
When I come to the point with respect to whether it was appropriate for the Commission to have ordered an inquiry, when we know that there was a police inquiry, I think there's more an issue of fairness. Was it fair for the Commission to have made the comment it made and then made the recommendation for another inquiry, knowing that There was already...
You'll have to persuade me that that is an issue of fairness, but we'll come to that.
Indeed.
Yes, but you've got the point that you're making, that the way the hearing was conducted was unfair to your client. Yes.
Now, the fourth issue on which we'll address your Lordship is having regard to the disabled status of the appellant. The Commission breached the principles of fairness and natural justice in failing to adopt reasonable adjustment to give the appellant a fair opportunity to take part in the process of the Commission. That is an issue which my learned friend Suku will develop in the course of his address.
Thank you.
Lord, may I proceed to deal with the issues in the order I have just stated. So the first issue is whether the Judicial Review Court erred in law when it found that the impugned extract set out in page 4 of the Judicial Review judgment did not amount to findings by the Commission.
Thank you.
My Lord, we have set out the various judgments of the Supreme Court in our written case, but I will very briefly perhaps submit on the law as it stands today. The first pronouncement of the Supreme Court of some significance is the case of Gopi. It's a 1987 case, Gopi against Sir Maurice Rowe, 1987, which is at 1228 of the electronic bundle. In that case, my Lord, the court held that the findings...
So could you have the page again?
It's 1228.
28.
Yes, my Lord.
Thank you.
And we have analyzed it at page 837 of our written case. In that case, I mean, there is no dispute with respect to that pronouncement of the Supreme Court. The Supreme Court has held that the findings of a commission of inquiry, which are unjustly or unjustifiably prejudicial to the character or reputation of a person, are subject to judicial review. A clear pronouncement by the Supreme Court that to the extent that we are dealing with findings which are prejudicial to the character and reputation, that would be subject to review. That principle...
Are you looking at 1228? Are you reading from 1228? Because I didn't find...
I don't think you're reading from 1228. 1228, I think, is where the judgment starts, but then you're referring us to page 18 in your case.
1235, my Lord.
1235, sorry, 1235. Thank you.
Now, that judgment, my Lord, the principle which is enunciated in Gopi was applied subsequently in the case of Gajadhar and Pari. The case is dealt with at electronic bundle page 1076. There does not seem to be any controversy with respect to that particular finding. A year later, in the case of Ramjiawan and Sir Maurice Rowe, that's a case of 1988, I would like to refer your Lordship particularly to page 1324, 1324, and which is analyzed in our written case at page 838.
Could you give the could you give the paragraph number of your written case as well, please? Because with the paper
Indeed.
copy we have of your written case,
it is analyzed at paragraph
bundle numbers.
I'm sorry. It is analyzed at paragraph 62 of our written case.
62. Yes, I see that. Thank you.
You know, in the case of Ramjiawan, the Supreme Court held that once the Commission of Inquiry had decided to interpret its broad term of reference in such a way as to take up and consider allegations against individuals and make specific findings ad hominem on their conduct, a particular duty arose which requires the Commission of Inquiry to apply high standard in the assessment of evidence on the conduct and character of the individual concerned and to observe the rules of natural justice.
That's once that findings are made.
Indeed.
I thought we were dealing with the question whether they are findings.
Indeed. What I wanted to do, Milady, is perhaps inform the board of the evolution of the law in Mauritius on findings and observation. The next thing I was going to come to was precisely those judgments where initially the Supreme Court felt that when it comes to observation, these are not reviewable, but then your ladyship will see that it's a position which has evolved because subsequently the Supreme Court seemed to have accepted that even in relation to observation, to the extent that these observations are prejudicial, they may be reviewable.
Jadu, the Supreme Court says it may not matter.
Indeed.
So are you saying it doesn't matter, or are you saying that these are findings?
My submission to your ladyship, to your lordship, will be that in the context of the present case, these were clearly findings.
You say they were findings?
They were findings.
But you say that the later cases indicate that even if they are just observations or comments, if they are sufficiently prejudicial, then this statement in Ramjiawan about the need to apply principles of observe the rules of natural justice would apply prior to making those kinds of comments and observations.
Indeed, milady, your ladyship will see that we have referred to a case, the case of Jagnat and Balgobin, which is at page 1162 of the electronic bundle, and which is also referred to in the written case at page 842.
And paragraph number, if you wouldn't mind, for your written case.
Yes, my lord, I will. Now, the
71, I think.
It's at paragraph 71, my lord.
Yes, I see. Thank you.
Now, the point to make is this, that the case of Jagannath establishes clearly that even comments would be reviewable to the extent that the comment, what the court said, that the comments made in that case, there were findings, there were comments, but they were more lethal than findings of fact. And the court proceeded to review the comments which were made in that case. If I may come back to the point I was making. So there was a point in time when the Supreme Court seemed to have reached the view that to the extent we were dealing with observation, those observations would not be reviewable. And in that respect, my lord, I would like to refer your lordship to the case of De Robillard, 1992, which is in the electronic bundle at page 1042. And the relevant extract is at page 1043. De Robillard is dealt with in our written case at page 839 and 840. It's paragraph 63, my lord. Now, the case of, we also refer to the case of Feyafe and Matadine, the case of 2001, which is at page 1069 of the electronic bundle. It is referred to in the written case at page 840 and paragraph 66. And finally, the case of Ramgulam and Matadine, which is at page 1308 of the electronic bundle. I would like to direct your lordship or your ladyship more particularly to page 1311. The case of Ramgulam is analyzed at page 840 of our written case at paragraph 67. Now, these cases, my lord, at that point in time, I have no quarrel with those cases because perhaps the nature of the observation were not prejudicial, hence the reason why the Supreme Court reached the view that to the extent that we were dealing with observation, comment, these were not reviewable. Now, the next case we wanted to refer your Lordship and your Ladyship to is the case of Roman and Joseph, a case of 2002. It's at page 1347, and more particularly page 1349. The case of Roman, my lord, is dealt with at page 842 of the written case, and that is paragraph 69. Now, interestingly, in Roman, the court reached the conclusion that the observation in that case amounted to an adverse finding and proceeded to review the observation made in that case. Now,
sorry, where's that on page 1349?
Roman is...
No, where did they make that finding?
I will...
Right at the bottom.
Oh, yes, I see. Thank you.
Roman is considered in the written case at page 842, lady.
There they seem to, sorry, on page 1349,
indeed,
at the end of the judgment, they seem to say indeed, that although it's described as an observation, it is in fact an adverse finding. What was the observation that they were referring to?
That is the observation which is to be found 3 paragraphs preceding the final comment.
She
that
was
is,
a witch.
Mrs. Roman then started to accuse her of misconduct and of having recourse to witchcraft. Mrs. Roman even brought to the gymnasium a male witch accompanied by her husband. The witch stated these were the observations which the court ultimately reached the conclusion were findings by the Commission. We know the last step in the evolution of the law came with the judgment of...
Just to hesitate a moment, I mean, what seems to be being said is that the evidence doesn't tally with the observation made in the final chapter, and then they quote the evidence. So where is the observation that is impugned in this case? We need to see the context of these statements in order to give them...
I think it's 1348 at 10.
9:10.
I'm reading from 1348. In their report to the President, the respondent have in the final chapter entitled General Observation stated the following. We also doubt the conduct of Mr. Roman in his dealing with the Federation was disinterested and free from any intention to safeguard and protect the interest of his wife and his son in the Federation instead of that of the Federation as a governing body on the weightlifting field. We note that serious allegation that he brought Saucier Blanc, a witch, to the training center to ascertain whether Mouguin and other athletes were conspiring with occult help against his son. We can only say that the behavior of Mr. Roman was a barrister by the way.
So that last sentence could be treated as an observation.
Yeah, indeed.
As could the doubt as to whether his dealings were disinterested. Yes. Okay, thank you.
Thank you. Now, the last judgment we wanted to draw your lordship's and your ladyship's attention is the case of John Bocus, all right, which is against Lam Shang Leen, which is at electronic bundle 1136, more particularly page 1144. My Lord, the case of John Bocas is considered in the written case at page 844.
Paragraph 74, I think.
Indeed. Now, what we draw from the case of John Bocas, the case of John Bocas, milady, my Lord, has been summarized, if I may say, in the case of Stephen, a judgment which we refer to, and which is at page 1368, if I'm not mistaken. Now, the position as stated following the case of John Bocas with respect to the principles followed in Mauritius with respect to findings and observation are as follows: that a finding or decision of a commission of inquiry set up under the Commission of Inquiry Act is amenable to judicial review. So when it comes to finding and decision of a commission of inquiry, that is clearly amenable to review. The court proceeded to say that any decision, albeit a recommendation, which has the character of finality or quality of finality in the decision-making process for the determination of the issue at hand by the Commission, would be reviewable subject to all other conditions for judicial review being fulfilled. I understand that to mean that to the extent that it is in breach of the rules of natural justice, ultra vires.
Yes. Where are you quoting from? Reading from, please.
That is 1144, my Lord.
This is 11.
Oh, we're back to...
So back to 1144, because you then said that it was summarised in another case,
Stephen.
and you gave us...
It is indeed summarised in the case of Stephen, my Lord. Stephen, which is at page 1368. 1368.
Wouldn't it be better to look at it in the judgments?
Indeed.
In Judge John Bocas itself.
I'm not sure that...
No, that reference is not right.
I think it's 1362.
It seems to be...
Can we go to page 1362, my Lord?
At 1368, you say?
62, I'm sorry.
62.
Yeah.
But that seems to be... It was the Stephen case about this same commission report that is concerned in the current...
That is indeed the case. The case of Stephen summarizes the position in law as it sees it from the case of Jadu John Bocas. I'm quoting from the judgment of Stephen at page 1362.
1363, yes.
Yes, top of 1363, where it says such a decision include firstly conclusion of the Commission reflected in its ultimate decision to recommend further inquiries and any action which may be deemed fit by the relevant authority. And secondly, comments or observation made by the Commission which are in fact adverse finding on the applicant and which may have considerable adverse consequences on the applicant's reputation. As I indicated to your Lordship, your Ladyship, our submission at the end of the day will be that, look, in this case, we were clearly dealing with a finding which was prejudicial to the appellant. And even if your Lordship, your Ladyship were to find that, no, these were not finding, our submission will be that they were in the nature of comments or observation which clearly were adverse, prejudicial to the character and reputation of the appellant and hence reviewable. Lord, let me come to the findings of the Commission with respect to the appellant. I believe that before we come to the findings specific to the appellant, it is important to go to the title which the Commission uses at the address on a number of barristers whose conduct are considered by the Commission. I would like to take your lordship, your ladyship, to page 434 of the electronic bundle, which reproduces the relevant part of the Commission finding. The Commission had this to say. The Commission has very strong reason, in the light of the evidence adduced before it, to believe that there is a handful of barristers who may have acted and may still be acting in the most unethical manner, if not engaging in illicit activities such as obstructing the course of justice, intimidating witnesses, and causing witnesses to diverge from their original statement version, thereby abstaining from incriminating certain drug barons. From there, I would like to take your lordship to the remarks of the Commission, or perhaps I should say finding of the Commission, at paragraph 19.5.4.
Well, it goes on under the heading specific cases before you get there,
Yes.
to say that the Commission would not have called these barristers had it not received information of potential breaches.
Indeed. It said, however, the Commission would be failing in its duty. I'm reading from 19.5.4. However, the Commission would be failing in its duties if it did not comment on some of them in particular. The Commission would not have called these barristers had it not received information of potential breaches of the Code of Ethics. Most of the barristers were summoned by the Commission based on the evidence of communication with prisoners. Now, my submission to your lordship is that in determining whether the words used in respect of the appellant were finding, it is important to go back on this general remark made by the Commission.
Yes, I mean, essentially your case, I think, amounts to that in context, the Commission is saying that there is a prima facie case against your client.
Indeed, my lord. Now, having made those general remarks, then the Commission proceeded to deal with specific barristers, and I come to the part which concerns the applicant. That is to be found at page 444, my lord. If I may, the Commission writes the following. The Counsel Pyaneandee visited Rajan Vilvendro while the latter was in prison when he was not his counsel. His explanations were to the effect that Vilvendro's brother from Paris requested him to visit his brother in prison in relation to certain issues pertaining to his welfare. Mr. Vilvendro was, however, already represented by Sir Hamid Moulan QC. The Commission found it quite unusual that counsel also paid an unsolicited visit to Mr. Botswa in prison. Later, under oath,
Latter
under oath said that he never solicited Mr. Pyaneandee to assist him. He did not know who had sent him either. Counsel explained that he had paid a visit to one of his clients, Mr. Betty, and
was that on oath before the Commission or at the trial of Velvedron?
That was before the Commission.
So Mr. Botswa gave evidence to the Commission.
Mr. Botswa.
He gave evidence to.
It would appear he did.
I'd assumed that was evidence he gave in court, but I may be wrong.
It would appear. There's a part of the report where the Commission refers to those prisoners who had requested to be heard by the Commission.
Can you give us a reference for that?
Yes, I will. Now, in the case of Mr. Botswa, it would appear that he was called by the Commission himself, by the Commission itself, as opposed to him requesting that he be heard.
Again, if we could have a reference for that.
Indeed. Now, Your Lordship will find this at page 457, I'm sorry. And this is the title, Disgruntled Prisoners. The Commission received several requests from prisoners to depose before it, and before acceding to their request, the Commission inquiring team called upon them for a written statement as to the gist of their information. The next paragraph, Your Lordship will see that it says the Commission called only 3 of them who made complaint against counsel and 2 notorious traffickers, and their name follow.
They don't include Mr.
They don't include Mr. Botswa.
So who did he or did he not give evidence to the Commission?
I do not dispute the fact that he would have given evidence. I am not sure, but I don't dispute the fact that he would have given evidence before the Commission.
Well, the Commission presumably knows, so maybe they can take some instructions.
Yes. Thank you.
But the written statements were never provided to you?
No. Milady, when Your Lordship will go through the transcript of the proceedings, Your Lordship will see that to take one example, at page 815 of the electronic bundle, I'm reading from the transcript. The chairperson of the Commission, I think line 22, page 815. The chairperson says, I am sorry, this is not what he said in his statement to the police, and before us, I assume from these that Mr. Botswa would have given evidence.
Yes.
I would like to
But presumably the report will indicate somewhere everyone who did in fact give evidence before them.
Strangely, my Lord, I have gone through the reports. Exceptionally, I see that the report does not set out the name of all those who have given evidence before the Commission.
Yes.
I come back to the remarks, if not to say the findings made by the Commission. At page 444 of the report of the Commission, the allegation made by Mr. Botswa against counsel is very serious, asking him not to implicate Mr. Vilvendro in return for financial reward.
So where are you reading from now? I'm so sorry.
I am at page 444, my Lord.
Thank you.
Reading from the report of the Commission.
Oh, yes.
With respect to Mr. Pyaneandee.
Yes, thank you.
So the words of the Commission, the allegation made by Mr. Botswa against counsel is very serious, asking him not to implicate Mr. Vilvendro in return for financial reward. And then the Commission goes on. Mr. Ernam deposed and was very critical of the acts and doing of counsel in the present matter, with document in support. Mr. Botswa is the same prisoner who had made complaint against Mr. Gulbul, who tried to convince him in return of cash not to implicate Mr. Vilvendro. The role of Mr. Pyaneandee is very suspect indeed. My Lord.
So can you just explain, because it's not really explaining who these different people are. Mr. Hernam, I gather, was he senior counsel for one of these prisoners at their trial?
Indeed, my lady.
Well,
Mr. Ernam was a counsel who appeared for Mr. Vilvendro at his trial. But it is interesting it is important for your ladyship to bear in mind that Mr. Ernam would have given evidence before the Commission against Mr. Pyaneandee.
Yes, and
Right.
is that Mr. Dev Hernam, the campaigner?
Indeed.
The counsel and campaigner.
So-
Yes, the board has encountered him before. Yes.
So Hernam was senior counsel for whom at their trial?
For Mr. Vilvendron.
Yeah.
Vilvendron. Against whom Mr. Botswa would have given evidence at the trial.
And the documents in support, have you ever seen those documents?
These documents were never shown to the appellant. The appellant was never confronted, neither with the evidence of Mr. Hernam nor the document. But it is interesting, my Lord, my Lady, to see that the remarks, if not the findings of the Commission. He says the allegation of Mr. Botswa is very serious. Ask him not to implicate Mr. Vilvendron in return for financial reward. The Commission seeks corroboration of its finding, because then it turns to the evidence of Mr. Hernam, as if Mr. Hernam would have supported the version of Mr. Botswa.
What was the relationship between Mr. Hernam and your client? Was he his leader at this trial? Did Mr. Pyaneandee act for any of these people at their trials?
The appellant was not counsel in the case of Vilvendron.
So he was senior counsel for Mr. Vilvendron.
Indeed.
At his trial, and at that trial, Mr. Botswa gave evidence against Mr. Vilvendron.
That is correct.
Yes, and did Mr. Hernam say something that traumatized your client at the trial?
This is the evidence which the appellant gave.
Yes, well,
before the
reason you're being asked these questions is reading the evidence. One assumed that your client was in some way at the trial, and that Mr. Hernam said things within his hearing.
Yes.
Is that not the case?
No, the appellant was not a party or counsel in the case of Vilvendron.
Right.
But it would appear, my Lord, I have to concede that somehow, because your Lordship would have noted that the Supreme Court ultimately required that an investigation be carried out into the allegation of Mr. Botswa. And it would appear that in the course of the trial of Vilvendron, Mr. Botswa must have said things which were adverse to Mr. Gulbul and Mr. Pyaneandee. Hence, that led the Supreme Court to ask for an inquiry into the allegation of Mr. Botswa.
I thought, on the contrary, I thought that your case was that Mr. Botswa, at the trial of Mr. Vilvendron, had actually said in cross-examination that he'd not had a discussion about the case with Mr. Pyaneandee.
That indeed is the position of the appellant. When the appellant deposed before the Commission, he stated to the Commission that before the court in the trial of Mr. Vilvendron, Mr. Botswa had said that the appellant had not requested him to say anything.
But is there anywhere elsewhere in the report which sets out what Mr. Hernam's deposition was about the appellant here?
Nowhere, milady, nowhere. We don't know.
So there's nothing else in the report that refers to this criticism of the acts and doings of the appellant?
Indeed. And as I said, it would appear that the Commission sought corroboration, if I may use that term, in the evidence of Mr. Hernam for the findings which the Commission made with respect to the appellant.
We don't know what it was that Mr. Hernam said.
I only have the words of the Commission.
Yeah, well, that's what I'm asking you.
We have no idea.
What is it that traumatised the appellant?
Yes, because it may be said against you that the appellant
He knows something.
was aware of something about Mr. Hernam's allegation.
Because he says in evidence in the transcript that he was traumatised by something.
What I have from the transcript, indeed, when the appellant was questioned by the Commission, your leadership will recall that he had asked that part of the evidence would be in camera, and there was a refusal by the Commission. And he said, look, I was traumatized at the time of the trial, hence the reason I would have liked to depose in camera. But we don't know what was the nature of the exchange between Mr. Hernam and the appellant, if ever there was any exchange.
Thank you. But going back to the report itself, in relation to your argument about findings. I take it you're founding on the final paragraph in the discussion of your client. The Commission recommends that an in-depth inquiry be instituted to look into the role of council, which seem to have tried to pervert the course of justice in trying to shield traffickers. So really what it comes to, you're saying there's a suggestion that there's a prima facie case against him, and that's a finding.
Indeed.
Yeah.
I'm so sorry, I didn't understand your answer in relation to the traumatisation. Because I'm looking at the transcript, page 812, at it's about line 15.
Indeed.
So it's your client. He says, that was during the trial of Mr. Valvendron, when I was very much traumatised, then later I realised. So he seems to be referring to being traumatised during the trial of Mr. Valvendron. You seem to be saying he was traumatised because he was being heard not in camera
I
by the
am
Commission.
informed that he was not party to the proceedings. He was neither counsel or a witness or whatever.
So what's he? I mean, this is your client speaking. What's he talking about being traumatised at that trial?
We see him further up at line 8, I think. There was one senior in that his name was mentioned who actually really traumatised me in relation to the trial of Mr. Valvendron. Do we know what this is about?
I understand it to be that things which were said by counsel in the course of the trial of Mr. Valvendron.
But as we know that your client's case is that Mr. Botswa, in cross-examination, denied that he had been asked by your client to change his evidence in return for money. Presumably, your client knows that that was something that was put to him in cross-examination, even though he then denied it.
I can only
Well, we're all
read
speculating,
from the
but it might be useful to.
I don't have the transcript of the proceeding in the case of Valvendron. I am unable to assist your leadership in that respect.
Thank you.
My learned friend is drawing my attention to something which is said at page 808, that is the transcript. Yes. At page line 8, Mr. Pyaneandee, where the chairperson requests, why should there be in camera? Is there something so confidential? And he goes on to say no, even now, because I would want ideally to be able to finish off with that, because it's something that has, I should say, haunted my life for the past, and then it goes on. And this is where the chairperson put it to him, even Mr. Ernam, who pointed a finger at you.
But what do you want us to take from that?
Now, my Lord, your Lordship will see that he was about to explain, and then he was interrupted by the chairperson. He said, even Mr. Ernam, who pointed the finger at you. And then he says, exactly, I mean, it is this part of my testimony that I would like to be in camera for obvious personal reason. So he was inclined to give evidence to the Commission with respect to his whatever exchange may have had with Mr. Ernam, but to the extent that the evidence was not in camera, he had refrained from giving more detail.
Right.
But, I mean, let's focus on we can come back later to the question of the fairness of the trial. Your point, the focus at the moment is on whether or not there were findings adverse to your client.
You know, their Lordship before the Supreme Court reached the conclusion that notwithstanding what is said under the heading Black Sheep, the paragraph that followed that heading and the words that were said at the address of the appellant, their Lordship before the Supreme Court reached the conclusion that these were not finding. My submission to your Lordship is that on an analysis of what was said by the Commission, my submission is that clearly we were dealing with findings in relation to the appellant.
But is that really right? I mean, at page 444.
Yes, my Lord.
And then on to 445. I mean, they say the role of counsel Pyaneandee is very suspect.
Is very suspect indeed.
Yes, but they're not reaching a conclusion as to what he's done. And at the end, they say we recommend that an in-depth inquiry be instituted. So wouldn't the inquiry be to find the facts?
My Lord, with respect, when the words "the role of Mr. Pyaneandee is very suspect," that is preceded by the words which are used by the Commission. The allegation made by Mr. Botswa is very serious, asking him not to implicate Mr. Velvander in return for financial reward. My submission is that when the Commission goes on to say the role of Mr. Pyaneandee is very suspect indeed, one must take those statements together, because when the ordinary man is reading these findings or remarks, the only conclusion is that the appellant would have interfered with the witness with a view to clear a trafficker.
But even in relation to Mr. Botswa, it's an allegation. I mean, the Commission doesn't say we accept that allegation and find as a fact that his evidence is correct.
I do bear this in mind to the extent, my Lord, with respect, to the extent that the Commission goes on, and says that the allegation is very serious, seeks support for that remark in the evidence of Mr. Ernam. My submission is that clearly we're dealing with a situation where the Commission was making a finding and not purely and simply an observation, or setting out purely and simply the allegation of Mr. Botswa.
Is it your case that the finding they made may not have gone as far as saying that he did this, but that it's still a finding that there's a prima facie case worthy of investigation to find out whether he did it? Are you saying that's a separate finding of fact? Or?
Lindy, let me put it this way. If the court had said, this is the evidence of Mr. Botswa, this is the evidence of Mr. Ernam, and we refer this to an inquiry, I would have had no quarrel. But the manner in which the Commission has proceeded, making value judgment, if I may say, with respect to what the appellant would have done, my humble submission is that these clearly, either they are findings, if not, they are clearly observations which were clearly prejudicial to the appellant.
Yes,
I would like.
In summary, this point is that you have to read what is said about your client at 444, 445 in the light of what is said earlier in 434.
Indeed,
that on a proper construction, this is either a finding of a prima facie case, indeed, or an adverse observation.
Indeed.
Yeah. Thank you.
May I move on? There are two sets of events. The first set deals with the evidence of Mr. Botswa. The second set deals with the evidence relating to someone by the name of Altaf Jiva. Now, I'm still reading from page 444. The Commission goes on to say, these are events which took place in 2006. As per the prisons, sorry, as per the prison.
Where are you reading from?
I am reading from bottom of page 444, milady.
Yes.
As per the prison's visitors book for legal practitioners, counsel on one occasion visited 5 prisoners, including Mr. Altaf Jiva. But he, however, told the Commission that he had no knowledge of this and that he did not know Mr. Jiva. Now, the Commission goes on. There was no reason for counsel to meet Mr. Jiva, who had never retained his services. And then the question is asked, was he acting as a spy for other more important drug dealers? And the danger of such visits already pointed out by the Commission. You know, these remarks that there was no reason for counsel to meet Mr. Jiva, who had never retained his services, followed by a question which is more in the form of a suggestion. Was he acting as a spy for other more important drug dealers? And the danger of such visits already pointed out by the Commission. Now, your Lordship would have gone, your Ladyship would have gone through the transcript. The appellant is asked, have you met Mr. Jiva? He's deponing in August 2017.
Now this all relates to the fairness question. Are you moving on to that, or are you still on the finding?
I'm still on the finding. I will come to the fairness question. Now, the appellant is asked about his whether he had any encounter with this gentleman by the name of Jiva. He said, I can't recall this name. I don't know this person. And then your Lordship would have seen that, look, he said that when I went to the police, I gave my statement to the police, it occurred to me that my name would appear in the record of the prison. And I think an inquiry is called for. To the extent that the Commission had said that, look, this is what the record of the prison revealed, and that the appellant could not recall having visited the prison, having visited this gentleman, and that we order an inquiry. I have no quarrel with that. But then your Lordship would have seen what he says is this. There was no reason for him, as if, as a matter of fact, he did meet that gentleman. And then followed by the question, which, as I said, is more of a suggestion that he indeed was acting as a spy. You know, my submission to your Lordship is, if your Lordship does not agree with me that these were findings made by the Commission, then my submission, the alternative submission, would be that they would still be reviewable in the form of observations which were clearly prejudicial to the character and reputation of the appellant, who was a barrister at law, who at the time of his deposition, my Lord, was a vice chairman of the UN Committee on the Rights of Persons with Disabilities, and he was also decorated by the President of the Republic of Mauritius. You know, I have done with the issue of whether these were finding. If not finding, they were observation. May I move on to the issue whether the Supreme Court was right in not...
Please do, because you have to cover the other 3 issues. Indeed. Because Mr. Chuchai makes the point, even if this is amenable to judicial review, you have to address these as well.
Indeed. Indeed.
So if we move on to issue D now, whether the Supreme Court were right to determine the matter without a transcript. Without
the transcript. You know, before I come to this, I would like to make one preliminary observation. I do realize that the point was not taken in this case before the Supreme Court as to the propriety of the Commission having put in an affidavit without the transcript. I say this because, Your Lordship, I would like to invite Your Lordship's attention to the pronouncement of the judge in the case of Stephen. Now, can I take Your Lordship, Your Ladyship, to page 1356 of the judgment of Stephen. I am at page 1357, middle of the page. We would open a parenthesis here to observe that we found it surprising that the respondents should have considered it appropriate to put in affidavit in which they appear to be seeking to justify the content of their report and to refute the accusation made by the applicant in his own affidavit. We consider that an affidavit would only be very exceptionally be required from members of a body which is now functions official. For example, where the record has to be set straight in view of the blatant inaccuracies presented by the appellant, or as in the case of Ganga and Sakasamulan, allegations of communal bias were made against a member of the Commission and were strongly denied by all members who affirm that their report was a unanimous one. In normal cases, it would be enough for the Secretary of the President of the Republic, who has the custody of the record, to put in, as the fourth correspondent has done in the present case, an affidavit appending relevant extract of the proceedings where the reasonableness of the impugned finding of the Commission is being questioned in the light of the evidence that was adduced before the Commission. And the transcript of the proceedings may assist the court in determining the issues in dispute. Now, it would appear that the approach adopted in the case of Stephen stems from the approach which was adopted in the case of Gopi also.
What's the date of Stephen? Sorry.
Stephen is a case of 2022, my lady.
I mean, Stephen seems to be talking about a different sort of case, about where there's a challenge to the reasonableness of the findings made by a commission, where the objection is that someone has been treated unfairly and in breach of natural justice. I would have thought typically that will depend upon evidence of what actually happened in the proceedings before the Commission, as to which evidence would be required. I would have thought perhaps a better point for you is that insofar as evidence is required about that, there is a duty of candour on the Commission to provide a full account of what happened.
I certainly agree with what your Lordship is saying, and the point we make before this board is that, look, in view of the dispute between the conflict between the evidence of the appellant and the Commission, the Commission ought to have called for the transcript. But before I come to this, I wanted perhaps to invite the board guidance for future cases, because it would appear that the approach of the Supreme Court has not been all that consistent, because in this case, your Lordship would have seen that there was production of the transcript. In fact, the judge made the remark that it was not appropriate for the Commission to put in an affidavit. It would have been sufficient if the transcript alone was placed before the court. And as I said, that followed the practice, the stand adopted in the case of Gopi as far back as 2007.
Yes, when it speaks about the Secretary providing an affidavit, essentially the affidavit would simply be saying, here are the relevant excerpts.
Indeed, that is
giving evidence.
Indeed.
Himself or herself.
But what was the timing of this Stephan judgment in relation to the evidence put in the present case before the Supreme Court by the Commission? Are you saying that the Commission, in putting an affidavit into the Supreme Court in this case, was disregarding what had already been said in Stephan, or did Stephan come after that?
It appears that, I mean, milady, this case was heard before the case of...
Right. So the judgment in Stephan came after the affidavit was put in this case.
Indeed. Now,
thank you.
Now, the other observation I wanted to make, Milady, my Lord, before we deal with the need for the transcript. Your Lordship, your Ladyship would have seen, I would like to direct your Lordship and your Ladyship to the letter which is found at page 818. 818. That letter sets out the various attempts made by the appellant right from the 7th of August, the day on which he deposed before the Commission, where he requested for a copy of the transcript. On the 14th of August, that request was refused. He renewed his request on the 8th of August. Again, that was declined on the 13th of August. 13th of August, he wrote to the correspondent number 4, renewed his request. Again, he was refused. He lodged an application to the Supreme Court on the 23rd of August to get hold of the transcript. That application was registered until ultimately there was an application for judicial review of the finding, in which there was a prayer that the record be brought. Now, Your Lordship, your Ladyship will note that although the attention of the Judicial Review Court was brought to the unusual stance of the Commission in not producing the written transcript, despite the applicant's motion to the said court to cause the record to be brought, the Judicial Review Court, in our humble submission, erred in view of the conflict of evidence as between the Commission and the applicant. Now, one can perhaps go back in time, at the point in time when the affidavits were exchanged. Clearly, there were sharp contradictions as between the appellant and the Commission, which warranted, in my humble submission, that the transcript be brought before the court. I don't propose to go through those conflicts. Your Lordship would have noted the affidavit on one hand of the applicant. I will allude to some of the dispute between the applicant and the Commission. But let me say this. It is perhaps important for your Lordship to go to page 583. That's the judgment of the Supreme Court. And can we perhaps start at page 581, where the court sets out some of the evidence, the averment in the affidavit of the applicant, where the paragraph 38, which is reproduced at 581, to the best of my recollection, the Commission had failed to confront me with the allegations made by Mr. Botsoa. To the best of my recollection, the Commission never suggested to me that I was trying to pervert the course of justice and try to shield drug traffickers. To the best of my recollection, the Commission had failed to put to me the evidence of Mr. Ernam, who, according to the Commission, was critical to me. Further, the Commission failed to put to me the documentary evidence. To the best of my recollection, the Commission...
There, 41 is quite significant, isn't it? Because there is a dispute. It's suggested by the Commission that your client was given the evidence of Mr. Hernam, but if we look at the transcript, he wasn't.
That is indeed the case, my Lord. And I was going to come to this. Your Lordship will see the response of the Commission. Before I come to that, Your Lordship would also note that, to the best of my recollection, the Commission did not provide me with an opportunity to verify whether I had visited Mr. Jiva. And then, to the best of my recollection, during my testimony before the Commission, it was never put to me that there was evidence that I was acting as a spy for other drug dealers. Now, Your Lordship will see at page 582, the respondent denies the allegation, the averment at paragraph 38 to 40, and then proceeds to say that the applicant was confronted with the allegation of Mr. Ernam relating to the same matter.
Yes.
The Commission goes on to say that the respondent denied paragraph 41, precisely dealing with Mr. Ernam. And then further down at paragraph 30, we are still on page 582, respondent denies the averment at paragraph 44, that is dealing with the suggestion that he was acting as a spy. The Commission say that during the hearing, applicant was informed of the consequences of making unsolicited visit in prison, that he made such visit to prisoners Vilvero and Botswa. Applicant was equally informed of his visit to prisoner Jiwa. Applicant confirmed that those prisoners were indeed not his client. That is not what the applicant said. The applicant said at the time he deponed before the Commission, he could not recall having met this gentleman. The position of the Commission was...
He did say that Vervendran and Botiswa were not his clients, did he not? It's Jiva that he didn't recall what his involvement.
I'm referring to Jiva, no. That is indeed the case. Yes. Paragraph 44, my Lord, is dealing with the remarks, not to say the finding of the Commission that he was acting as a spy for other drug dealers, but because that bit is to be seen with respect to the findings of the Commission as regards his exchange with his alleged meeting with Mr. Jiva. Now, can we turn to page 583? This is what the Supreme Court said. The language used by the applicant in his affidavit, to the best of my recollection. Your Lordship, Your Ladyship will bear in mind that he had right from the outset asked for the transcript.
You want to read the sentence before that?
Yes, please. In judicial review proceeding, this court is not sitting on appeal, and its role is not to resolve disputed issues of fact. We, however, believe that any conflict between the above versions of the applicant and the Commission as to how the proceedings were conducted before the Commission is more apparent than real. I don't think that is so, milady, because when we read the transcript...
I know. That's what they said.
Indeed. Now, so I was about to come to the judgment of the Supreme Court. The language used by the applicant is the affidavit. To the best of my recollection, is uncertain, speculative, and verges on a fishing expedition. On the other hand, the Commission has given a precise, detailed version of the proceedings in the course of which the applicant gave evidence before the Commission. And of the tenor of his evidence, the Commission's version clearly shows that the allegations of Botswa and Mr. Ernam and other material facts were put to the applicant, and that the latter was given an opportunity to respond and did do so.
And your point is that the transcript does not justify that.
The transcript indeed shows
also that the Commission presumably had the transcript and your client didn't have the transcript.
That is precisely my point, milady.
Is there a duty of candour on public authorities in judicial review proceedings?
Lady, there is clearly the... with respect to the chairman of the Commission of Inquiry, he's a former judge of the Supreme Court. One, of course, would have expected that candour coming from the Commission.
Yes, I mean, is there Mauritian case law on the duty of candour? If you don't know offhand, this is perhaps something that you can submit a short note to us afterwards on.
So, milady, I think when one looks at the relevant part of the judgment, clearly my submission is that in view of the conflict between the evidence given by the appellant in his affidavit and that of the Commission, my submission is that the Supreme Court ought to have called for the transcript and that the Supreme Court erred in law when it didn't. I have done with the issue of whether the Supreme Court ought to have called for the written transcript. And I move on to the third issue, whether the Supreme Court erred in law when it failed to hold that the findings were reached by the Commission without due observance of the law of evidence and in breach of the rules of natural justice. I would like to refer the board to Section 7 of the Commission of Inquiry Act. That is at page 1000 of the electronic bundle. It says that the commissioners shall, after taking the oath provided under Section 5, make a full, faithful and impartial inquiry into the matter specified in the Commission and shall conduct such inquiry in accordance with the direction in the Commission. So there is the duty on the Commission to make a full, faithful and impartial inquiry. Further, can I take your lordship, your ladyship, to Section 13 of the Act? Now, Section 13 says that law of evidence to apply. Any enactment relating to witnesses and evidence shall, subject to this Act, be applicable to all witnesses appearing and to all evidence given before the Commission. Now, I would like, in this respect, to take your lordship to the case of Gopi, the case of Gopi, which we referred to earlier, which is our electronic bundle 1235.
This was in relation to an earlier commission, also into drug trafficking.
Yes, I am at 1235, my lord, my lady.
Is this
Last paragraph.
1235 at line?
It's 40.
Yes.
We have seen that Section 13 of the Act required the Commission to abide by the law of evidence. In this connection, the Commission also had an obligation to act in accordance with the rules of natural justice. That obligation was particularly important as the Commission well realized in its introduction to the chapter on drug traffickers, and which we have earlier highlighted, since its finding might otherwise be unjustly and unjustifiably prejudicial to the character and reputation of innocent persons. Now, my submission to your lordship is that to the extent that the Supreme Court found that Section 13 imported an obligation to act in compliance with the rules of natural justice, my submission to your lordship will be that when one takes Section 7 and Section 13 together, there is an obligation on the Commission to act fairly. So there is a duty of fairness in my humble submission which is imposed on the Commission.
I don't think that's contested, as far as I understand. The argument against you is that what took place was fair.
Now, I stress on the obligation of fairness because of the following. You know, we're dealing with an appellant who had been sworn in 2001. The incident with respect to Mr. Botsall would have occurred sometime in 2002, that is a year after he was sworn in. The judgment of the Supreme Court was delivered in 2003, and this is where the Supreme Court ordered that there be an inquiry. The appellant, in the course of his deposition, said that I was interviewed by the police in 2004.
So, what was it that prompted the inquiry? The trial of Mr. Velvedron?
Indeed, indeed.
Who was presumably convicted as he was now in prison. Yes.
Now, the point I want to make is that the Commission, my Lord, was clearly conscious, aware of the fact that as far back as 2003, there has been the suggestion, not to say the recommendation by the Supreme Court, that there should be an inquiry. We have a Commission who is fully alive of the fact that there would have been this full police inquiry. The Commission is aware of the fact that the inquiry had been completed and it had been submitted to the Office of the DPP for advice.
And when was that? When was it completed?
Now, when the applicant was deposing before the Commission, milady, on the 7th of August 2017, he wrote to the Commissioner of Police, and that is in part of the evidence, and the Commissioner of Police reverted back to him to tell him that, look, yes, the file...
I'm just asking the date.
We're aware of that evidence. The question is simply, when did it go to the DPP?
When was it completed and when did it go to the DPP?
That is at page 26 of the electronic bundle. It said, I wish to inform you that the case file is at the Office of the DPP since 10th of March 2017.
But is that when it was completed, 10th of March 2017?
It would have been completed by 10th of March, milady.
Do we have in the bundle the judgment of the Supreme Court in following the trial of Velvedron? Which,
indeed.
Where is that in the bundle?
It is. The judgment, milady, of Velvedron is to be seen at 1463. It will start at 1442. Yes. We have indeed made sure that the judgment of Velvedron...
And that then prompted that police inquiry?
Indeed, indeed. Now,
is the conduct of the appellant that led to an inquiry referred to in that judgment?
Yeah.
It's not expressly, the appellant is not expressly referred to, and I believe that what was said that at the end of the judgment, Your Lordship will see, in view of the nature of the allegations which were made against some barristers.
What are you reading from?
1472, milady, I'm sorry. Below, bottom of the page. In view of the nature of the allegations which were made against some barristers in the course of the present proceeding, the Master and Registrar shall cause a copy of the proceedings to be brought to the notice of the appropriate authorities for their attention for any action which they may deem fit. Your Lordship and Lordship will find that we see Mr. Ernam, Mr. Domingue and Mr. Kissun appeared for the accused there. And the state was represented by Mr. Rashid Amin.
So is there nothing in the judgment that identifies who the allegations were against?
No, I have reviewed the judgment. There is no such indication, milady. Now, The point is this, as I was saying to submitting my lord, that we are in 2017 before a commission of inquiry who is perfectly alive of the fact that there had been this recommendation by the Supreme Court, there had been that inquiry which was conducted by the police. That inquiry had been completed. It was submitted to the DPP for advice. My submission is that what purpose did it serve?
Is this a fairness argument at all, or is this a rationality argument about the outcome? I mean, the normal ambit of the duty of fairness relates to what happens in the hearing itself. I mean, how do you bring the recommendation of an inquiry into the scope of the duty of fairness?
My lord, I think I would say both. Not only the manner in which the Commission proceeded, but it was clearly unreasonable, irrational on the part of the Commission, knowing.
But you don't have an appeal on the ground of rationality, do you?
Yeah, but then.
Well, I don't know about my colleagues, but I'd be more interested to hear the arguments about procedural unfairness. What do you say was unfair in the way that your client was questioned?
I say it is unfair.
What do you want to do?
I think that they didn't.
Yes, okay. You can ask about that.
I don't think
Okay.
to say there should be an in-depth inquiry.
The point I suppose that you can make is that there was no apparent recognition in the Commission's report that there was this prior inquiry.
Indeed, nowhere in the findings of the Commission as regards the appellant did the Commission refer to the inquiry. My submission is that clearly it was as I said, I drew the attention of your Lordship to the requirement of observance of the law of evidence, section 13, where the court said that, look, it imports an obligation to act in compliance with the rules of natural justice. But I go further and say, look, it was incumbent on the Commission. It was incumbent on the Commission, knowing that there was this inquiry, to at least make reference to it. Perhaps I should go further and say, look, there was no reason for the Commission to call Mr. Botswa to make the remark it made, knowing that there had already been an inquiry.
Well, that's a different point. I think it seems to me there's 2 points about the police investigation. The first is, I think you can say, whether or not it was irrational for the Commission to say there should be an in-depth inquiry. It was unfair of them to make that recommendation without also stating in the report that there had been a thorough investigation by the police of all this, and so far no action had been taken against your client, and that would have put a different complexion on it. There's even if they might then have gone on and say, well, we think this should be looked at again or something like that. But then there's a procedural point, which my lord is emphasising, which is that during the course of the hearing, should the Commission, that's a point about the fairness of the court's procedure and what the court wrote, but there's a separate point about the fairness of the Commission, whether in his hearing before the Commission they should have enabled him to see the statements that he had made to the police in order to refresh his memory as to what his response had been to these allegations at an earlier point in time closer to the events which had occurred. I think there are 2 separate points there.
I think In reaction to your leadership remarks, it has to be said, contrary to the findings made by the Commission in relation to another council where the Commission expressed its dissatisfaction with the police inquiry. In the case of the appellant, nowhere did the Commission say, look, we had any apprehension, we had any reservation with respect to the police inquiry. But what is extremely important is that when the appellant deposed before the Commission, my Lord, I think there are at least 8, if not 10 occasions where the appellant constantly referred to this statement. Can I perhaps take your lordship, to those instances? Just to say that.
Well, you have to watch your time. You've got less than 5 minutes. That you can continue, but you'll be eating into your reply time if you do.
I'll be very brief on this minute.
No, but we do want to hear you on the question of fairness. It is an important issue.
Now, can I? Now, I wanted to draw your lordship's attention to page 805. I'm reading from the transcript. Almost penultimate paragraph. The appellant is speaking. And I realized that at that time I gave a full statement to the police. Now, the appellant who is being questioned is bringing home to the Commission that, look, this is a matter which has already been inquired into. Page 806, at the bottom of the page, last paragraph. No, if I may, I said back, that's from memory, because I gave a full statement and a warning to the police regarding both. Now, the next page, 807, just after line 10, but from my statement and the warning, I explained that very clearly, the circumstances of my acquaintance with this person. Now, this is important because let us see the reaction of the chairperson. Well, so you are confirming what we have been aiming at, that you have been going on unsolicited visit. You never requested, he never requested you because his version is completely different. You tried to convince him to accept the gift which Mr. Vilvandro was going to give, so that he does not implicate the latter. That is what he told us as well. Anyway, this is why you have been called. It's not because the inquiry was started at the time of the assizes, because the judge referred the matter for inquiry. We know what happened to the inquiry. We have a copy of the inquiry. Now, I was here to say, my learned friend, with respect, says this is a question, this is not an assertion. When one looks at what the chairman said, my submission is that clearly the Commission of Inquiry had the police inquiry in its custody. Your Lordship will find at page 811, line 13, again, the appellant refers to the statement which he gave. At page 814...
Where was that, sorry?
Yes, my Lord. He says, if I am able to refresh my memory with statement which I gave...
I'm sorry, which line? It's about 12.
811, line 13.
811, I'm sorry.
Sorry. Yeah. Yes, thank you.
Might be appropriate to take your Lordship, your Ladyship. This is extremely important because that deals with the allegation with respect to prisoner Jiva. almost bottom of the page, the appellant is speaking. Chairperson, may I say something? That's to the best of my ability to give you an explanation. There has been instances, especially during the course of when I was giving my statement to the police with the MCIT, that things very funny cropped up, that there are people who were not my client but yet were on the list of prisoners that I have allegedly visited. I honestly don't know this person. Now the point is this. So all throughout his deposition, the appellant referred to the statement. My submission, I go even further. I say my submission to your Lordship is that it would appear that the Commission had the...
Does the Commission acknowledge that? I mean, has the Commission, in its evidence, said that they do have the...
No. What happened, my Lord, when the appellant referred to the inquiry by the police, your Lordship will know that the Commission does not admit, does not deny the fact that there was the police inquiry. But nowhere does the Commission acknowledge the fact that it was in presence of the police file.
Well, they presumably know whether they had it or not. I don't know why they're expecting other people to prove it.
So, my Lord, really, the point I want to make is that in relation to the allegation made by Mr. Botswa, with respect to the remarks, observation, finding made by the Commission to the address of the appellant as regards the allegation of Mr. Botswa, I say this: the remark and even the recommendation were unreasonable because, to the extent that we already had an inquiry, it was clearly inappropriate, unfair for the Commission to make the recommendation.
Again, you're straying from fairness into unreasonableness. We don't have a case of an unreasonable decision. What we are inviting you to address us in the very limited time you have is on the unfairness of the way the proceedings were conducted.
Can I say this? With respect to the unfairness, my Lord, the point was taken before the Supreme Court that the appellant was not given the opportunity to cross-examine witnesses who had given evidence against him. Now, the point was specifically taken, and the Supreme Court reached the conclusion that the procedure to be adopted by the Commission was something left to the Commission, so that there was no need for cross-examination. In this respect, we refer your Lordship to the case of Ramjia 1, which is at Electronic Bundle 1324. Now, 1324, middle of the page, secondly, as indicated earlier, the Commission took care to conduct the examination of the applicant accuser, Frivet, in public after he had been heard in camera, but omitted to ensure that the applicant was present at the time and was given the opportunity to confront and cross-examine him. And it goes on, Mr. Matadin, for the respondent, argued that the applicant, although in abscondiae, was an experienced police officer. My submission to your Lordship is that where the Commission decides to make specific observation ab hominem on someone, relies on evidence given by other parties, there was an obligation on the Commission to allow the appellant to cross-examine. And in that respect, my submission is that the Commission had failed to allow the Commission, to the appellant to cross-examine his accusers, if I may say. Now,
very briefly, what was the nature of the allegation in the Ramjia 1 case? What was the inquiry directed to do?
Ramjia 1 was a police officer who had been against whom evidence would have been assured by a gentleman by the name of Frivet. The gist of the allegation would be that as a police officer, he had been taking money from drug traffickers and so on and so forth.
Yes, I think we see that at 1322.
Indeed.
Where the allegation is that there's not a single policeman who's got clean hands. That's at lines 12 to 20.
Indeed. So,
and what was this a case where the committee or the commission made a finding of fact that the policeman had acted corruptly?
Indeed.
I mean, it wasn't simply calling for a further inquiry.
The court reached the conclusion that the findings made by the Commission were clearly ad hominem, and in that respect ought to have allowed the applicant there.
My question is, what was their finding that there had been corruption, or was it a lesser finding?
I think the findings of the Commission was that there was indeed a recommendation for a further investigation, but I think I believe the findings of the Commission was that there were allegations of corruption against the officer in question.
I think it's on 1323. It cites paragraph 18 of the Commission's report.
1223.
1323.
1323, thank you.
18.1.
Yeah, 18.4. We find on the whole his explanation concerning the several deposits to be very doubtful. We agree with Frivet. He tolerated the drug traffickers. Those were the allegations. Very, very briefly, I say that the findings, observation of the Commission were clearly in breach of the rules of natural justice, to the extent that the Commission relied on the evidence of Mr. Ernam, which evidence, as I said, will never put to the appellant.
Not even the gist was put.
Neither the gist nor the documents which apparently Mr. Ernam would have placed before the Commission.
Was that referred to in the affidavit that the Commission swore provided for the Supreme Court?
I think yes, paragraph 27
indeed.
says the allegations.
Whilst the appellant had contended...
I see, but they didn't expand on what those allegations were.
No. So no one knows what Mr. Ernam would have said. That is what I wanted to say in relation with the findings of the Commission as regards the exchange with Mr. Botswa. As regards the findings with respect to Mr. Jiva, my submission will be that clearly there was no evidence placed before the Commission, or should I put it this way, there was no evidence of which the appellant would have been confronted, which could show that he was acting as a spy, as the Commission would have it for other drug traffickers. Your Lordship, your Ladyship would have seen the transcript. My submission is that those remarks, especially when it comes to prisoner Jiva, were clearly unwarranted. As I said, the position of the appellant was that deponing almost 11 years after the event. He said, look, I can't recall. What I can recall is that when I gave my statement to the police, funny things cropped up. It would appear that my name would have been mentioned. But nowhere was it suggested to him, was it put to him that, look, as regard Prisoner Jiva, you were acting as a spy. So in that respect, my submission is that the findings of the Commission were in breach of the rules of natural justice because he was never confronted with the evidence on the basis of which the Commission would have found that he was acting as a spy. I have done with my submission. Unless your Lordship or this would have any other question, my learned friend Suku will address your Lordship on the last point with respect to unfairness to the appellant being in the condition he was.
Yes.
Sorry, can I just ask one other question?
Please do.
Sorry. One of the points that's made in some of the cases that you've cited in your written case is that evidence of some of these witnesses, like Mr. Bottaswa potentially and Mr. Jiva, who are convicted drug offenders, should be treated with a high degree of caution in relation to the making of adverse comments about a barrister or a police officer. Is that something you rely on?
Indeed. Lady, we apply the same rules of evidence which are applicable in England in the sense that if you're dealing with a witness who has a purpose of his own to serve, one must be cautious with respect to the evidence which has been given.
Yes. Yes, you have eaten up already 10 minutes of your reply time, so I would invite Mr. Suku to address us briefly.
My lords, my ladies, I will propose to make 4 points on issue A in the agreed statement of fact. That issue has been reproduced at page 798 of the bundle. Our written case on issue A is at page 865 to 866. Our arguments run from paragraph 131 to 133 of our written case. My lords, my ladies, we make the following 4 points. The appellant was not given a fair opportunity of participating in the process of the Commission on an equal basis with a non-disabled witness before the Commission. Firstly, because at the start of his deposition on the 7th of August 2017, the appellant informed the chairperson that from where he was, it was difficult for him to hear the chairperson. That is at page 804 of the electronic bundle at line 27 in the written transcript. We say that the Commission did not deem it fit to ask the appellant to come closer to to the chairperson during the questions being put to him. We also say that simply asking...
So this is page 807, line...
805, line 27. 805, line 27. We further say that simply asking the appellant to come closer to the chairperson was an adjustment which could not have unduly burdened the Commission. The Commission counter-argues. The Commission says before you that the Commission resorting to repeating questions in the event the appellant could not hear the said questions was proper, and that the appellant was agreeable to that. The case for the Commission is at page 908 at paragraph 56A of the written case for the respondents. We invite the board to reject that proposition. We say so for the following 2 reasons. Firstly, the appellant was only agreeable to that course after his request to have Dr. Hosier by his side was rejected by the Commission. From then on, we say it is a legitimate proposition that the appellant was left with no other choice than to proceed as directed by the Commission. The second point, the Commission resorting to repeating a question upon the appellant not hearing that question was not a reasonable adjustment which could have been made. It would appear that the burden was shifted on the appellant because it is the appellant who would have then to stop the chairperson when allegedly he would not have heard the questions put to him. Our second proposition, you will have noted, the appellant was refused the assistance of Dr. Hosier during his deposition. We say that is material for two reasons.
And can you just say who Dr. Hosier is?
Yes, I can. We would like to apprise the board. Dr. Hosier is not a medical practitioner. She bears the title of doctor because she is a lecturer in law, and she is also, as at the 7th of August 2017, she was the partner of Mr. Pyaneandee. You will find Mr. Pyaneandee making reference to that at page 804, line 30, where he refers, and I quote, my partner, personal assistant. So page 804, line 30 from the written transcript.
But she wasn't a legal representative.
She was not the legal representative, indeed. We say that the not allowing Dr. Hosier to be by the side of Mr. Pyaneandee was material for two reasons. This was because the appellant was deprived of having someone by his side for the purposes of understanding the questions put to him. We also say this was material because the appellant was deprived of having someone who would have taken the notes during his deposition, be it during his deposition or after that.
What was she allowed to stay in the room when the evidence was taken?
Unfortunately, the written transcript does not reveal that.
I think it suggested that she was there, but not beside him.
Yes, definitely. That is the position, yes.
So she could take a note?
She could take notes.
She could have taken notes.
Yes.
And when you say take a note, do you mean on a braille machine or you mean a written note?
It would have been written notes from paper and pen. Someone
on the appellant's side could have kept a record of the proceedings.
Yes.
You accept that?
Yes, correct. Now, so that is a point made by the Commission that any of the assistants of Mr. Pyaneandee could have taken notes. That is at page 905 of the electronic bundle at paragraph 54A. We humbly suggest to the board, however, that for the note-taking exercise to have been an effective one, it would have required the note taker to be next to Mr. Pyaneandee so that Mr. Pyaneandee could have informed her of any issues that he would like to be put down on paper. This is the humble suggestion which we make to the board. The Commission argues that neither did the appellant produce any documents, nor did the Commission produce any documents which Mr. Pyaneandee would have required to consult, and therefore the need for personal aids were not required. We admit that that is the case. There were no documents produced either way, but we humbly suggest to the board that the point remains that having a personal assistant by the side of Mr. Pyaneandee would have been material either for understanding questions or for note-taking purposes. The Commission also counter-argues at electronic bundle 907 at paragraph 55. The Commission argues that on a close examination of a written transcript, the Commission did not foreclose the possibility of the appellant seeking the help of his personal aides. It is important that I invite the board to turn to page 907. We are looking at paragraph 55B of the written case of my learned friend. which reads, and I quote, "The Commission stated that in the case of the appellant, need, between inverted commas, the help, emphasis added there, as opposed to help, of his personal assistance, it was open for the appellant to request for such help." And the appellant relies on the extract, of course, if there is a need for the help, you may ask. Now, can I ask the board to turn to page 805 from where this extract has been taken? We say, the point which we say is that this is an incorrect reading of a written transcript. In fact, when we turn to page 805, we are looking at line 9, where the chairperson says, of course, if there's a need for the help, you may ask. It is crucial to read the preceding line. Mr. Pyaneandee states, and I quote, "If I can't hear, I will ask from time to time, maybe speak up." We say that the correct interpretation of the help at line 9 is referring to line 8, which is either the chairperson speaking up or questions being put twice. The second reason why we say this interpretation should be rejected is because when we look at the evidence of the Commission itself before the Judicial Review Court, that is to be found at page 122, paragraph 8b of the Commission's affidavit. We see at 8b, the evidence of the Commission before the Supreme Court was, and I quote, "The Commission gave due consideration to the applicant's qualms, and at the start of the hearing, the latter was reassured that there was, and I'll stress on those words, there was no need for his assistant to be by his side."
Sorry, what page are you reading from there?
Yes, my lady. Electronic bundle 122.
122.
And this is the affidavit.
First, correct, my lord. First affidavit of the Commission before the Judicial Review Court, paragraph 8b. The case is made that there was no need. There's a crucial distinction to be made between there being no need and that possibility now being foreclosed, which is an argument which has been made before you now, and which we invite the board to reject. The third point, we say that the absence of reasonable adjustments even resulted in the appellant being confused during his deposition, and here we invite the board to consider two extracts from the written transcript. The third extract is at page 813 at lines 1 and 2, page 813 lines 1 and 2.
I think given the time that is available to you, you better just give us the references and we can look at them later.
Noted, my lord. So we are page 813, line 1 and 2, where reference is made to
Yeah, I do apologise. It's been pointed out to me that 2 times were applied to the appellant. It was 10:30 to 12 and then 12 to 12:30. So you are perfectly within time.
right. Much obliged, my lord.
I haven't appreciated that unusually the two periods have been set out in the pre-lunch adjournment. So you're not in fact eating into your reply time.
I'm obliged, my lord.
Proceed as you wish.
I am grateful. So I was on the subject of the 2 instances where Mr. Pyaneandee appeared to be confused.
And that's at 813
line 1 and 2. So Mr. Pyaneandee states, "No, I was never sent. I don't think I ever appeared together as a junior or ever worked with Mr. Jiva." Mr. Pyaneandee seems to be understanding whether or not he appeared together with counsel instead of a detainee. It is not in the written evidence before you, but we wish to disclose to the board there is a senior member of the Mauritian bar who is called Mr. Ahmad Jiwa, Jeewa. And Mr. Pyaneandee seems to understand that he's been talking about Mr. Jiwa, counsel. Instead, he's been talking about detainee Jiva, Jeewa. Second instance of confusion, 807, lines 21 and 22. We are at lines 807, lines 21 and 22. The last sentence in the extract from the chairperson, we know what happened to the enquiry. We have a copy of the enquiry. Now, the question of Mr. Pyaneandee does not follow. He says, happened to whom? There's some room to say that he's in a confused state at that time.
I'm so sorry, my fault. What was the page reference for that?
Yes, my lord?
807.
807, lines 21 and 22.
Yes.
And that wasn't answered.
Correct.
Mr. Pyaneandee says, happened to whom? And the chairperson doesn't say, you misunderstood.
He does.
Just carries on with something else.
Indeed, my lady. So, therefore, when the Commission argues before you at page 908, at paragraph 56C of its written case, that the appellant did understand the questions put to him and he answered them coherently, a finding also made by the Supreme Court at page 585, lines 8 and 9, we say that this ought to be rejected. Our fourth and final point, my lord, you will have noted at page 79, on the 21st of July 2017, the appellant did make a request to the Commission to be assisted by his personal aide, inter alia, for note-taking purposes. Page 79. We just wish to bring to the attention of the board, the Commission does not reply to that letter. In fact, it is only on the day of his deposition, on the 7th of August 2017, that Mr. Pyaneandee learns for the first time that he will not be afforded the assistance of Dr. Hozier. We make the short point here. We say that had the appellant at least been informed in advance that the assistance of Dr. Hozier would not be afforded to him, it is a legitimate proposition that he could have planned in advance his appearance before the deposition. We say that for a disabled person like Mr. Pyaneandee, the ability to engage in advanced planning is an important point. And we give two examples of advanced planning. Had he been informed that Dr. Hozier would not be there to help him, on the day of the hearing, he could have resorted to using hearing aids, or secondly, he could have requested the Commission to implement effective methods of making orally delivered information available to persons who are hard of hearing, either by implementing assistive listening devices or by supplying Mr. Pyaneandee with headset amplifiers. And we say that none of those adjustments unduly burden the Commission or were disproportionate in nature.
Yes, but in fact, there was no question of him having been disadvantaged by reference to documents. The case of disadvantage in this case must rest on his hearing disability.
Agreed, my lord.
And did he use hearing aids? You said he could have, in advance, planned to use hearing aids.
He did not, my lady.
Does he have hearing aids?
Did he then?
I mean, is this just speculative?
I'm not. What would Dr. Hozier have done? Does she just repeat the questions in his ear, or how does that work? How would that have worked?
Our understanding is precisely that. She's also the partner of Mr. Pyaneandee.
Yeah. We understand that, but
she would have repeated her questions.
So the complaint really, insofar as he misunderstood things, she could repeat the question.
Yes.
But she was able to be in court and take note, in the hearing and take notes.
Indeed.
Well, and also the 2 points that you say, the potential confusion with Mr. Jiwa and Mr. Jiva, she could have said, or happened to whom when they were talking about the inquiry. She may have been able to intervene at that point and say, no, you've misunderstood.
Indeed, my lady. Agreed.
Yes.
My lord, my ladies, that is my time, unless I can be of any help to you.
I apologise for misleading you about the eating into reply time. You have in fact completed your case on time.
Much
Thank you very much. Mr. Chuchai.
Thank you, my lord. Lords, my ladies, may I start with a couple of references that may be useful before I forget them. I think in relation to your question as to whether Mr. Botswa, forgive me if my pronunciation of some of the names alters between English and French, or some hybrid, but referring to dealing with Mr. Botswa and whether he gave evidence to the Commission, the answer is he did. And there are 3 references to that point in the transcript. In order, page reference, page 806, lines 16 to 17, 807, line 18, and 815, line 23.
Is there anything in the Commission's report that reflects the gist of what he said?
I don't believe so. I don't believe so, but I suspect that...
We have no idea what he said beyond the vague allegation.
We have no idea what he said beyond what we can read in the transcript, so far as Mr. Botswa is concerned. Yes, that's correct.
But do you accept that at the trial of Mr. Velvedron, Mr. Botswa had denied in cross-examination that the appellant in this case had said anything to him about that?
I don't accept that in the sense that the evidence at trial, in terms of the original transcripts of the evidence at that trial, are not before the court. What I do accept, obviously...
Were they before the Commission?
Yes, but it's not the case, I'm afraid, as I stand here now, it's not the case that I'm aware of every single piece of paper that may be in the possession of the Commission. My point is simply that there is no evidence, there was no evidence before the Supreme Court about that aspect. I accept that there is such evidence available, but it wasn't deployed by either party in the context of the proceedings in the court below, and therefore I can't myself therefore assist your ladyship as to the actual position. I don't understand the Commission's position to be hostile, if I can put it that way, as to what the transcript says Mr. Pyaneandee said about that during that part of his evidence. We can see what he says, and certainly his evidence in the transcript, as it stands, is as you summarize. The effect of that is a different question. And the treatment of that by the Commission is a different question. But I will come to that, if I may, in due course. But that's all I can say so far as the underlying facts are concerned as to what happened at that trial.
And when you're saying that the Commission is not hostile to what the appellant said in his evidence as recorded in the transcript, can you just point us to the page, what exactly you're referring to?
Well, I'm referring to the passage. Forgive me, despite the relative shortness of this document, I'm always amazed at how long it can take to go through it and find the relevant passages. But it is the one where forgive me.
I think it's on page 807, at the top of the page.
Yes.
asked why I've come to see him, and he said
Yes.
under cross-examination, under oath during that time, that in fact I
Yes.
never discussed the case with him.
Yes.
Is that the passage you're referring to?
Yes, that is the passage that
And
I'm
when you
referring
say
to.
the Commission isn't hostile,
Well, let me clarify what I mean by that, because I think that's ambiguous.
Yes.
I accept the transcript says what it says. In other words, I accept for the purposes of this appeal that that the appellant's evidence to the Commission at the hearing was to that effect.
But do you accept the sort of truthfulness of the underlying fact that's being referred to here, that there had been an incident during the trial of Mr. Velvandron where Mr. Botswa was cross-examined by Mr. Hernam and denied that the appellant had discussed
I don't know that.
Your position is you don't know.
I simply do not know whether the appellant's evidence was true or correct.
But you accept the Commission was told that.
Yes.
And nothing was said in the report about it.
do you accept that it was part of the Commission's role to probe into that, if that's what the appellant was saying, and the Commission was going to recommend an inquiry into the appellant's role as a result?
Well, there is a question of proportionality that I will come on to, because one of the big issues that is at play is when you have a commission of inquiry, where, for example, as in this case, it's a massive endeavour that lasts 2 to 3 years, and the commission has the widest possible range of tasks that faces it. To what extent does one take the view in relation to any particular witness's evidence that the Commission effectively should conduct, if not a full-fledged trial, but a sort of mini-trial in relation to any particular dispute of fact or conflict of evidence in relation to a particular witness. It's a difficult issue, and I can certainly accept conceptually that different people, different judges, different individuals may have different reactions to how far down the line members of a commission in a particular case should have gone. I accept that.
But that may depend, of course, on what the Commission was intending to conclude. Were they intending to make a finding of fact that someone had definitely done something, or were they intending to simply to conclude that there needed to be further inquiry?
I entirely accept that.
It will depend, presumably, on what the Commission anticipated its conclusion would be.
Yes, and that in turn may depend upon when exactly the Commission decided it had investigated sufficiently to be able to reach a view as to what it felt able to say. So it's all very interconnected.
Yes, because a witness could say something early on in an inquiry which could have a great significance later on, which wasn't realised at the time. And did one have to recall the witness every time?
Yes.
A witness every time that was occasioned.
Yes.
I can see there might be a great difficulty.
Yes, and the other sides, in fairness, do make the point that they suggest that effectively what should have happened is this sort of ping-pong process whereby not only is it the case that the appellants, not only is it the case that the other witnesses' versions should have been put to the appellant, but that the appellant's version should also have been put and effectively pressed upon the other witnesses, each of them, which obviously then raises the question, well, where does that process stop? When one gets the evidence of those witnesses, should one then go back to the appellant? And how far does that? How long does that process go on for? And I agree with you. At the end of the day, one has to step back, and in a sense, you have to start from what you have in terms of what either the findings, if there are findings, or observations are, the potency of those statements in the context of the report as a whole. I accept that, and in the light of that, take a view as to whether what in fact happened was fair.
But the potency of the allegation that's recorded in the report, which says that Mr. Betessoir made a serious allegation against the appellant, that he had effectively offered him money to change his testimony so as not to incriminate Mr. Velvedron, was it not relevant for the Commission also then to say, however, actually when he was cross-examined by this at the trial, he then he withdrew that allegation and said that Mr. Pyaneandee had never discussed the case with him. I mean, if that had been how it had been expressed in the report, that would have put a rather different complexion on it, wouldn't it?
I can see that would be a fair point if it were established as a matter of objective fact that Mr. Betessoir had indeed effectively given inconsistent evidence. But the point I was making earlier is that all that we know...
don't know. Well,
surely the Commission knows, or have looked into it, didn't they?
They must have.
But also, either they inquire into it, and there are all these proportionality issues, or they at least flag up that there is an alternative view that's been expressed by this appellant. You can't have it both ways, can you?
Well, I see that. I think one of the problems, potentially, and again, I don't know all the facts, but of course the transcript only emerged relatively recently.
But surely the transcript was in the Commission's hands, right?
Yes, but again, there are questions as to exactly where the transcript was. I'm not necessarily able to answer that. What we do know is that attempts were made, I think sometime last year, to obtain it from the Secretary of the President of the Republic. That effectively.
Are you saying that the Commission, when they were writing their report, did not have transcripts of the evidence that they'd heard?
Well, I don't know whether they had transcripts of the evidence readily available as they were giving their evidence, as opposed to the positions
when they were
writing their report.
Oh, their report?
Yes.
I don't know for a fact, but I imagine that they will have done.
Yes. So they would have had this answer given by the appellant about what happened in the trial of Mr. Velvedron.
Yes.
And they could have qualified what my lady has just put to you, described as a serious allegation.
I accept that. They could have done. But on the other hand, what they did do, which is a point that is completely skated over by the appellant, is that they set out the appellant's version. So in terms of the gist of the information, or the two opposing sides, if I can put it that way, of the story, they put both sides.
Well, except that on one side there'd been a withdrawal of the allegation at a certain point. Well, it might be said that's not a fair presentation of the overall picture, so far as Mr. Betessoir is concerned.
Well, I'm not sure that it would necessarily be right to describe it as a withdrawal, because I'm not sure of the precise chronology. Because if it's right that Mr. Betessoir came to give evidence to the Commission itself, it certainly appears as if he's...
No, but top of page 807 is referring to what happened at the trial of Mr. Velvedron. So that's in 2002 or something like that.
Yes, it would have been a withdrawal in the sense that if in fact what happened, Mr. Betessoir had given different evidence, effectively consistent with the evidence that he later gave to the Commission, and he gave that to the police initially. Then he was cross-examined at the trial, and he gave different evidence. I accept that. All I'm saying at the moment is that it's not entirely clear to me that is necessarily how it happened.
Right. Just while we're on page 807, can I just ask what you say are the underlying facts in relation to the statement by the chairperson at lines 20 to 21, where he says, we know what happened to the inquiry, we have a copy of the inquiry. So that's referring, I think, to the inquiry
police
recommended, yes, recommended by the Supreme Court at the end of the Valvendron trial, as I understand it.
Yes.
So should we proceed on the basis that the Commission did indeed have a copy of the materials relating to that inquiry?
Well, the answer is no, because our position is that the Commission is simply, or the chairperson is simply asking a question rather than actually making an assertion.
I don't see how he can ask the question. I mean, if I say to you, do I have a copy of the key documents bundle in this case, you would say, well, you know whether you've got a copy of it or not. Why doesn't the Commission know whether it's got a copy of the inquiry report?
I accept it's not clear, but I am not able to...
There's a question mark there, but why on earth would you be asking the question? It's like me asking I have things in my pocket. What does it tell you? Nothing.
But also, it has to be read with the first part of the sentence, where he's positively asserting, we know what happened, and then he explains why. We've got a copy of it.
Yes.
It just looks like a mistranscription. The question mark is just a mistranscription, surely.
But what is... I understand that, but what in my respectful submission would be, in a sense, pretty shocking, and I would be, if the Commission did have the police file, which would have contained the statements of the appellant, the previous statements of the appellant, but the exchanges that took place that we can see, for example, at the very end of the hearing, did in fact take place, which obviously they did, because that would suggest, on that analysis, effectively the chairperson was deliberately misleading the appellant as to whether the Commission already had all of that material. Now, that's a pretty...
Okay, but my question was a simple one. What is the factual basis on which the board should proceed in light of the statement made by the chairperson at page 807, lines 20 to 21?
Well, my position is, as we've set out in our written case, which is that he's not there stating that the Commission has the police file.
Well, even if he's not there stating, is it the Commission's case that they did not have the police inquiry?
I don't know, is the answer. This is not a point, this is not a factual point that's been raised before. It wasn't a point that was made.
Well, it is, because what's put by the appellant is, it was very unfair that you didn't show me the statement that I made to the police in 2004 to enable me to refresh my memory as to how I answered the questions then. And now you're asking me the same questions, and I want to know what I answered then when it was clearer in my mind. To which your answer seems to be, well, you've got to prove that we had those statements if you're going to accuse us of unfairness in not allowing you to see them. To which we're putting the point to you, well, why should he have to prove that? Either you had them or you hadn't, and you must know whether you had them or you hadn't, and therefore whether you have a defence to the accusation being made against you, that it was unfair of you not to show them to him to enable him to refresh his memory.
Yes, well, what's incorrect in what you've just said is the initial bit of it, where you said that the appellant was asking the Commission to provide the material. That's not how it happened.
Well, he said repeatedly in the course of the transcript.
Yes.
This was years ago, and I would like to refresh my memory. I made full statements about this nearer the time.
Yes.
And I'm looking at, for example, 811, where he said, if I'm able to refresh my memory.
He was saying that he would like the benefit of those statements.
Yes.
He was not asserting that the Commission already had those, and what in fact happened after the hearing, or what happened at the end of the hearing, is the chairman said to him, if you look at page 817, all right, so thank you, we have your version. If ever you think that you come across your own statement, if you want to tell us more, please do so, okay?
But sorry, page 816, right, bottom of 815, top of 816, the appellant is positively asserting that he rebutted certain things in the course of the earlier police investigation. Top of 816, he says, it's very difficult to recall things 15 years ago. But he then says, if you look at my statement in terms of chronology, I'm sure you perhaps have a complete different view. Because these statements even went to the DPP's office and said, I've not heard anything from anyone. And the chairperson says, yes, we know that. So, I mean, there's no particular reason why the appellant would have retained a copy of a statement he'd made to the police. And the chairperson seems to be expressing that he has knowledge of what has happened in relation to the police investigation.
No, with respect, that is reading far too much into, yes, right. We know that. Yes, we know that, as in, we know that you have given statements to the police or the DPP.
Or it may just be that he's recognising that the inquiry has gone to the DPP.
Or it could be that as well. And that's entirely consistent with his then saying at the top of page 817 to the appellant, well, if you do manage to get your statement and you want to say something, if you want to add to what you told us, then please let us know.
Well, that's certainly suggestive that the chairman did not have his statement.
It might be helpful.
Otherwise, he'd be behaving very improperly.
That's
Mr.
my
Chu Choi,
point.
can I suggest that we look at page 81 in the electronic bundle?
81.
Yes, well, that is the chronological, the next bit of the chronological.
This is a letter from the appellant.
Yes.
In which he states
to the Commissioner of Police, exactly.
I'm sorry? Oh, yeah.
Forgive me.
Yes.
This is a letter to the Commissioner of Police.
Yes.
And you're quite right to point out, I was going to point out that if you read the second part of the first paragraph to the end, you will see that he was given to understand that the Commission does not have copies of his statements. The Chairman has invited me to come back with my statement so that the Commission can be better enlightened in the matter. It would be much appreciated if you could kindly communicate to me my statements and the full brief to the Commission. And then the answer to that from the police superintendent you will find on page 83. And this ties in with Mr. Persham's earlier reference to the police file having been sent to the DPP on the 10th of March 2017. So certainly,
yes, we don't know whether what he was given to understand was actually the case or not.
Well.
Also, you don't have instructions. You're telling us.
Yes, I perfectly accept that there may be a serious question, particularly in terms of duty of candour, let's say. And one of the points I also wanted to make clear is that having checked the position with those who know better than I, there is a duty of candour under the Mauritian law of judicial review. And the case on it is, or at least one of the cases on it, is a Privy Council case called Peerless Limited. We'll make copies available later.
My recollection was there was such a
Limited and Gambling Regulatory Authority.
The case.
But the question, in fact, I just wanted to ask.
Yes, I'm so sorry.
Since the Commission is charged with inquiring into these events and it knows that there is a body of information relevant to their inquiry in the hands of the police and the DPP, wouldn't it be incumbent on them to obtain that information rather than leaving it to the appellant to do his best to obtain it?
Well, again, my answer to that is it goes back to the question of proportionality in the context of a huge exercise involving 306 witnesses and a very wide range of investigative tasks. There's a serious question as to, well, how far do you go? But I accept that we have to start, in a sense, with what they decided to say in the report about the appellant, and work back from that to assess the question of fairness. But if your question to me is, as at the date of the hearing, or in the days thereafter, should the Commission necessarily, at that point, have gone on to chase every bit of paper in that other police file, pursuant to their duty of candour, or in anticipation of whatever they might a year later decide to say about the matter? My respectful submission is no. But if they don't, I accept. If they don't, I accept that when it comes to looking at what they have decided to say, obviously the court may well take account, given the prominence, potency, or importance that they may have decided to give to that particular set of allegations or conflict of evidence and so on. The court will obviously then have to look very carefully at whether they've effectively got the balance wrong. I accept that. But perhaps, therefore, you can put those questions back to me that you're putting to me now, not by reference to how matters were proceeding at the time of the hearing, but effectively once they have decided or once they have published their report. And obviously I will have to address that, and I will do that as carefully as I can by reference specifically to the particular, more detailed criticisms that have been set out in the written case, because I think that provides a good roadmap for effectively addressing the challenging questions that you're putting to me right now, which are obviously important ones.
Would that be a convenient place at which to take the short adjournment?
I think it is.
Thank you very much.